Hello and welcome to a fresh episode of Legal Wrangle on International Taxation. To keep you abreast with the latest developments, we have selected three important cases. Our first case concerns validity of final assessment order passed and penalty imposed without complying with the mandatory provision of Section 144C. Our second case is about the waiver of interest under Section 220 following a MAP resolution. And our third case relates to the denial of custom duty adjustment on the ground of higher import content of assessee's business. Our first case involves a subsidiary of a major broadcasting company, namely Turner Broadcasting System Asia Pacific Incorporation. The main issue was whether the final assessment orders and the consequent demand notices would be valid, considering that the mandatory provision contained in Section 144C requiring the assessing officer to first frame draft assessment orders has not been complied with. Let's have a look at the facts in detail.
The assessee company had filed its return for assessment year 2007-8 and 2008-9. AO made reference to the TPO in respect of both the assessment years. Two separate orders were passed by the TPO. On the basis of these two orders, draft assessment orders was passed by the AO. These were objected to by the assessee before DRP. After the DRP concurred with the TPO, final assessment orders were passed by the AO. These were appealed against by the assessee before the tribunal. In both the appeals, tribunal observed that neither the assessee nor TPO had taken into consideration appropriate comparables, and therefore the determination of arm's length price was not justifiable. While setting aside the order of the DRP, the tribunal remanded the matters to the AO for undertaking a transfer pricing study afresh and framing an assessment in accordance with the law. Accordingly, TPO proposed an upward adjustment to the total income of the assessee for each of the assessment years. Thereafter, the final assessment order was passed, but without first issuing a draft assessment order. Accompanying the final assessment orders were notices of demand under Section 156 and 271(1)(c. Initiating penalty proceedings.
The High Court observed that in case of Zuari Cement Limited versus ACIT, the division bench of Andhra Pradesh High Court had categorically held that the failure to pass a draft assessment order under Section 144C would result in rendering the final assessment order without jurisdiction, null and void, and unenforceable. In that case, the consequent demand notice was also set aside. The decision of Andhra Pradesh High Court was affirmed by the Supreme Court. But in the present case, Revenue contended that the failure to adhere to the mandatory requirement of issuing a draft assessment order under Section 144C would at best be a curable defect. The court refused to accept the above submission. The High Court noted that the final position as explained in the various decided cases is unambiguous. The failure by the assessing officer to adhere to the mandatory requirement of Section 144C and first pass a draft assessment order would result in invalidation of the final assessment order and the consequent demand notices and penalty proceedings.
Now, let's move on to our second case concerning a company which is a part of a global conglomerate, DuPont. The issue in question was whether interest under Section 220 subclause 2 can be waived off if no genuine hardship is caused to the assessee from the payment of the said amount. To find out the answer, let's understand the factual matrix.
The assessee company is the branch office of Pioneer Overseas Corporation USA. It had been claiming exemption by treating its entire income as agricultural income in terms of Section 10(1) read with Section 21A, and this claim was also accepted by the department. However, while concluding the assessment for the assessment year 1997-98 and onwards, AO treated the entire income of the assessee as business income. The AO attributed the deemed income from research activity holding the petitioner to be a PE of Pioneer Corporation USA carrying on research activity in India. In 2005, Pioneer Corporation USA invoked the Mutual Agreement Procedure or MAP under Article 27 of India-US DTAA and sought resolution of the tax matters pertaining to the assessee. Consequent upon negotiations between the competent authorities of the two countries, an agreement was concluded with respect to allocation of taxing rights for the income taxable in India in the hands of the PE and setting off of the taxes paid in India by the assessee against the taxes payable in the US by Pioneer Corporation USA. On this basis, the assessment was finalized and taxes along with the interest were paid by the petitioner under Section 220. MAP ruling was finalized by the US authorities by providing tax credit in USA to the assessee for the tax assessed in India on 90% of income held to be business income. Assessee filed an application before the CIT for waiver of interest levied under Section 220. CIT dismissed the application on the ground that no genuine hardship had been caused to the assessee.
The High Court rejected the contention of the assessee that it had suffered genuine hardship as it had paid interest under Section 220 subclause 2, besides incurring costs on maintaining a bank guarantee which was more than 1.5 times of the tax amount. The court observed that the mere fact that the interest was 1.5 times the tax by itself does not have any relevance for determining whether the assessee was suffering from any genuine hardship. The fact that the assessee is a part of DuPont, a global conglomerate which had in 2011 $37.96 billion in net sales and $6.253 billion as operating profit, cannot be said to be an irrelevant factor in considering whether any genuine hardship was undergone by the assessee. Further, in comparison to the profitability of the assessee, over the years, the amount paid by it towards interest under Section 220 subclause 2 was merely $0.004 billion. Thus, waiver of interest under Section 220 was not granted as no genuine hardship was suffered by the assessee.
Now let's move to our last case where custom duty adjustment was denied merely due to higher import content of raw material of assessee company as the company was in first year of operation and largely dependent on the import of its raw material requirements be maintain the quality, standards and to establish itself in the Indian automotive industry. Let's understand the facts of the case.
The assessee company was engaged in automotive industry. It was largely dependent on the imports for its raw material requirements. On analysis of available data of comparable companies, it was inferred that on an average, the raw material import component of comparable companies is about 2.89%, whereas for the assessee company, this figure stood at 87.12%. The TPO denied this adjustment, holding that the business model of the assessee has been designed after factoring the import content of raw materials. It was observed that the assessee was selling its manufactured component column type power steering system to a single customer, Messrs. Mando Steering. Further, revenue submitted that no agreement was executed for deciding the price of components sold to Messrs. Mando Steering. Hence, it was not clear how the sales price was determined. It was also observed that as a normal business practice, all costs and overheads were factored in while determining the price. But the assessee did not produce anything either before the AO or before the DRP to show that import duty component has not been taken into account in deciding the price. It was concluded that the high import component of the assessee's business was not driven by any extraneous factor but out of own choice based on business strategy. The argument that it has come down in subsequent years does not explain the lack of support on the part of holding company in initial years to partly absorb this cost. Accordingly, AO passed the assessment order consequent to the passing of the DRP order.
The High Court placed reliance on the case of the CIT versus Demag Trains Components India Private Limited. In the said case, the tribunal had held that a higher import content of raw material by itself does not warrant an adjustment in operating margins. But what is to be really seen is whether this high import content was necessitated by the extraordinary circumstances beyond assessee's control. In view of this order of the tribunal, High Court remanded the matter to the AO with a direction to offer suitable adjustment against the custom duty components while determining the ALP. With this, we wrap up this episode of Legal Wrangle. Please send in your suggestions at editor@tiol.in. Keep watching TIOL Tube for our upcoming education video series Learning Curve. Thank you for watching.